Voluntary Disclosure Program for FBAR non-filers. A recording of the webinar will be posted on the website. Please type your questions into the chat box in the panel, and the questions will be answered at the end of the webinar. Let me introduce Dennis Brager. Dennis is a California State Bar Certified Tax Specialist and a former Senior Tax Attorney for the Internal Revenue Service's Office of Chief Counsel. He is a regular speaker at the national conferences and quoted in many publications. He has been retained as an expert witness in both federal and state courts. Welcome, Dennis.
Good morning. Thank you, Barbara, and good morning to everybody, and thank you for joining us. What I'd like to do is start off by spending just a few minutes on the basics and on the history of the OVDP, and then I'm going to move on to the changes. The sort of underlying assumption of this webinar is that everybody on this call has at least a basic understanding of foreign bank account reporting and the OVDP programs that have come before. And again, I just want to focus mostly on the changes. And I'll start by hitting the high points of those changes, and then we'll come back and try and look at some more detail. So we'll start off, of course, with the problem. If you've listened to any of my webinars before, you've seen this slide before, and you know that the basic problem is that a U.S. person who has signatory authority over or a financial interest in an offshore account must file an FBAR. The form is now FinCEN 114. The old form was TDF 90-22.1. That form must be filed if somebody has an account with combined balances over $10,000 US. U.S. person is defined to mean a U.S. citizen or a U.S. resident, and the term resident is also got its own set of definitions, but basically it means somebody who has a green card or who meets the substantial presence test, essentially in the country more than 183 days during the calendar year. It also includes entities formed under U.S. law. And so those people or entities need to file FBARs. And they also need to answer the question on Schedule B, yes or no, at any time during 2013, did you have a financial interest in or signatory authority over a financial account located in a foreign country? And if you check the box that says yes, you're required, it notifies you that you're required to file the FBAR and refers you to the instructions for exceptions. And the problem here is that if the individual checks the box that says no, when in fact the correct answer is yes, it subjects the taxpayer to a possible criminal charge of filing a false income tax return. And of course, on top of that, the failure to file the FBAR itself, the willful failure to file the FBAR is criminal. There are also very large penalties associated with the willful failure to file an FBAR, basically 50% of the account balance. That penalty can be imposed for multiple years, so you can have a situation based upon a 6-year statute of limitations of a penalty equal to 300% of the account balance. And for a number of years, everybody kept saying that, well, the worst case scenario was 50% penalty, because we'd seen in the criminal cases that the IRS prosecuted, there were only criminal cases that the IRS had prosecuted that they were only exacting 50% penalty. Well, that pretty much came to an end. There was a case, I guess it was last month, or maybe it's been a little longer now, Zwerner out of Florida, in which the IRS imposed 3 50% penalties, or 150%. Mr. Zwerner, who was 87 years old, went to court to dispute this accusation that what he had done was willful, and he had a trial before a jury, and the jury decided against him, and the jury agreed with the IRS on the imposition of the 3 50% penalties. So to reiterate, again, the worst case scenario may well be more than 1 50% penalty. So a little bit about the OVDP. It started out, it's been about 5 years now since the OVDP started. It originally provided for a 20% penalty instead of, of course, this 50% penalty structure that I was just talking about. So that was a substantial savings for somebody. That number got ratcheted up to 25%, and then ultimately it was increased to 27.5%. On June 18th, the IRS announced its 2014 OVDP program, which is generally effective for submissions after June 30th. The 27.5% penalty was continued. They did not ratchet that up any further. And they again reiterated that there's currently no ending date for the program, but the IRS could terminate the program at any time. So let's first talk about who's not eligible for the program. Generally, taxpayers who are under audit, whether or not related to offshore issues. And this came up recently. We had sent in a pre-clearance letter for a client, and were surprised to learn that, unbeknownst to the client, the IRS had scheduled an audit, and we couldn't go into the OVDP. Taxpayers who are under investigation by the Criminal Investigation Division already are, of course, not permitted to enter into OVDP, not a big surprise, nor are taxpayers who have illegal source income. So somebody who's embezzled money, drug money, those kinds of things, those taxpayers don't qualify for the OVDP. And that's consistent with the IRS's longtime voluntary disclosure program, which has always excluded individuals with illegal source income. So the OVDP penalties remain unchanged, 27.5% for the highest account balance at any time during the prior 8 years. The penalty base is not limited to the foreign financial accounts that are required to be reported on the FBAR, but it applies to all of the taxpayers' offshore assets that are related, quote, in any way to tax noncompliance. So, for example, if the client has a piece of real estate overseas, rents that real estate out, then even though the real estate was not required to have been reported on an FBAR, the value of the real estate is subject to a 27.5% penalty. If there's no income from the property, let's say it's a vacation home that the client owns in the Caribbean or Mexico or London or something like that, as long as it's not rented out, then there's no tax noncompliance, and therefore it would not be included in the penalty base. In addition to the 27.5% penalty, a accuracy-related penalty of 20% will be imposed, and if the original returns were late or payment was late, then the failure to file or the failure to pay penalties will be imposed. And of course, continuing on, same as it was under the old program, the taxpayer may not argue lack of willfulness and remain in the OVDP program. All right, so let's start moving along here and talk about the changes that have occurred in the 2014 program. And I'm going to summarize those briefly, and then we're going to go back and talk about these in more detail. So the new program has a 50% civil penalty, which applies to those taxpayers who have an account or use the so-called facilitator, perhaps an attorney, perhaps a banker, to establish or maintain the offshore accounts. And that institution or individual has been, quote, publicly identified as being under investigation or as cooperating with an IRS investigation. So here the IRS is, trying to ratchet up the stakes a bit. They don't want people waiting until the very last second when they know that their account information is going to be turned over to the IRS to get into the program. So they're trying to create an incentive here. FAQ 17 relating to FBAR filers who had no unreported income has been replaced with a new procedure, fairly similar, but nevertheless FAQ 17 itself has been eliminated. FAQ 18, which relates to the failure to file certain offshore reporting forms, has been eliminated and replaced with something new, which appears to be a lot worse, but we'll talk about that. You may recall that under the old OVDP, there was an opportunity for a 12.5% penalty, also for 5% penalties under certain circumstances. Those have all been eliminated, the idea being that the new streamlined 5% penalty is going to replace these old limited penalties, but they're gone. Some of the FAQs have been modified, in the words of the IRS, to promote clarity and consistency. What you see mostly is the addition of some language which makes things a little more difficult for taxpayers and more expensive. FAQ 23 now requires more information when you do a pre-clearance for a client. It used to be really simple. It's now gotten a bit harder. The offshore voluntary disclosure letter, that's the letter that goes in after the pre-clearance letter and after you obtain a pre-clearance. That letter and the attachments have been modified. The timing of the payment of the offshore penalty, the miscellaneous 27.5% offshore penalty, has been moved up in time, and some of the document submission requirements have been changed. So there's just a lot of changes at the detail level. We'll get into some of it, but if you've been submitting OVDP cases before, you're going to have to go back and look at the new procedures in excruciating detail. You can't necessarily use the old forms. You can't necessarily rely on what you knew before. So a lot of work involved here. So let's talk about this new 50% penalty set forth in FAQ 7.2. It is effective with regard to pre-clearance letters submitted after August 3rd, 2014. So if you've submitted a pre-clearance letter prior, or I should say on or before August 3rd, then this 50% penalty does not apply. It applies to taxpayers with undisclosed accounts if, when the pre-clearance letter is submitted, there's already been a public disclosure. And we'll talk about what that is in a second, but the public disclosure relates to the FFI, Foreign Financial Institution, or a facilitator, and there's a public disclosure that that individual has been under investigation by the Internal Revenue Service. If there's disclosure that the bank or the facilitator is cooperating with the IRS, or if there's been a court-approved John Doe summons that's been issued to the bank or the facilitator. The IRS gives a couple of examples of public disclosure. They talk about a filing in a judicial proceeding. So if there's an indictment that comes out, for example. They also mention a public announcement, such as a press release by the Department of Justice, for example, regarding a deferred prosecution agreement or a non-prosecution agreement of a specific financial institution. Apparently, though, simply news reports that hit the papers that are not part of an official DOJ release are not considered to be public disclosures. The IRS has published a list of those institutions which, for which a public disclosure, a disqualifying public disclosure has been made. And you can see that current list on your screen. It has a lot of the usual suspects: UBS, Credit Suisse, ZKB, Wegland, and I think you'll recognize most of the names on this list. So if your client has an account at one of these institutions, the 50% penalty applies to every account and all the assets. It doesn't matter where they happen to be. So, for example, if your client has a $20,000 account at UBS and $5 million somewhere else in the world, well, that 50% penalty is going to apply to the entire multi-million-dollar offshore balance. The IRS has said that the list that they publish is not necessarily 100% current. It can take them a few days to add an institution to that list. But the problem is that even if the institution isn't on this published list, if the public disclosure has already occurred, then the 50% penalty is going to apply. So let's say next week the IRS issues a press release saying that, I don't know, Israel Discount Bank has been cooperating with the IRS. And it takes them a week to update the list on the website that I'm referring to. It doesn't matter. If they've made the announcement, then the 50% penalty applies at that point. So right now there's a window of opportunity. If you have a client that's at one of these 10 or so financial institutions that's already on the list, or you suspect that the IRS is getting very close to going after a particular financial institution and making some sort of disclosure, if you get that pre-clearance letter in by August 3rd, then the penalty is 27.5%. If it comes in on August 4th, the penalty jumps to 50%. You certainly don't want to be in a position with a client of having that occur. And I think that it even after August 3rd has come and gone, with respect to financial institutions, specifically Swiss financial institutions who may soon find their way on that list, I think there's a real premium in trying to get the pre-clearance letter in as soon as possible, because your client can go to sleep at night thinking that it's a 27.5% penalty, and if the pre-clearance letter isn't filed, they can wake up in the morning and find it's gone to 50%. So I think that the sooner these things go in, the better. All right, let's move from the 50% penalty on to FAQ 17. You may recall that under FAQ 17, if a taxpayer had reported all of their offshore income, but the only problem was that they hadn't filed a foreign bank account report, the problem could be solved pretty simply. Send in the FBARs with an explanation, and no penalty would be imposed. There are some new delinquent FBAR submission procedures which now exist. They're very similar to old FAQ 17, but if you go looking for FAQ 17, you're going to see it simply says deleted. So you need to look for this new delinquent FBAR submission procedure. Going on to FAQ 18, that has been eliminated, and it's not clear exactly what the impact of that is. Under the old FAQ 18, if a taxpayer had failed to file offshore information returns, such as the 5471 or the 3520, but all of the income had been reported, then in that case, you would simply file the missing 5471s, 3520s, whatever the forms were, get those in, and there would be no penalty. FAQ 18 has been deleted, and in its place, there's these new delinquent international information return submission procedures. And under those procedures, you're required to submit a statement of reasonable cause, setting forth all the facts why there was reasonable cause for the failure to file. And the problem here is this suggests that if there's no reasonable cause, then the IRS is going to impose a penalty. And if you look at, for example, under the old FAQ 18, there was no requirement, no reasonable cause statement. It was very clear. It said just file the forms as long as there's no unreported income, there's no penalty. New procedure doesn't say that. You know, some commentators and some seminars that I've listened to have suggested that perhaps FAQ 18 doesn't mean what it says. And they point to the FAQ 32 and 35, where if you go into the OVDP program and you have some accounts which are compliant and some accounts which are non-compliant, you only pay the 27.5% penalty on the non-compliant accounts. So they say, well, it would be sort of strange for somebody, if you go into the OVDP and you're partly compliant, you get a pass on your compliant accounts, but if all of your accounts are compliant and you try and go in under FAQ 18, you could get stuck with a penalty if you can't show reasonable cause. And granted, this seems like an awfully strange result, but that seems to be literally what the current instructions indicate. So perhaps with a little time, we'll get a little more clarity, but this is something to watch out for. Frankly, we had a client who had this exact problem. There was no unreported income because there was no subpart F income, but there was still the requirement to file the 5471s. And we were getting all ready to get those 5471s filed. This new procedure came out, and we said, wait a second. Let's not rush to file them, because if we've got to show reasonable cause, that's no worse than what will happen if the IRS decides to audit. If the client can show reasonable cause, then there'll be no penalty. If they can't, there will be a penalty. So to me, this seems pretty problematic, and I hope the IRS clarifies this in the near future and lets us know that, in fact, I'm worrying about nothing, which would be nice. Well, the big news that was announced on June 18th is the Streamlined Procedures. It greatly expands and supersedes the old Streamlined Procedures that had been announced almost 2 years ago now. It's hard to believe that's been 2 years. So what are the changes? Well, for one thing, under the old procedure, there was a so-called compliance risk evaluation. And what would happen is that the IRS had a list of 8 or 9 factors that it would look at in determining whether there was a low level or a high level of compliance risk. And if there was not a low level of compliance risk in the IRS's eyes, and this was a completely subjective determination, the IRS could decide that you didn't qualify under the Streamlined Procedures. So we were putting a lot of time into evaluating whether or not there was a compliance risk for the purpose of deciding whether to put a client into the Streamlined program. The IRS has completely eliminated that evaluation. It has opened the program to U.S. citizens and residents, and by that I mean people living in the United States. So under the old procedures, only U.S. citizens and residents that were living abroad could apply for the Streamlined program. It also eliminated the rather strange requirement under the old Streamlined program that only people who didn't file a tax return could qualify. So if you had a person residing overseas, they were filing a tax return but not reporting all of their foreign income, they would not be, they were not eligible to enter into the Streamlined program. That has changed. The new Streamlined procedures now have 2 programs, one for U.S. taxpayers residing outside the U.S. and one for those residing inside the U.S. For both of those, well, I should say that I think I have said, prior to the new procedures, taxpayers residing in the U.S. would not qualify at all. They will now qualify. For both of those groups, there's no longer a $1,500 tax threshold. Under the old program, if you owed more than $1,500 in tax for any 1 year, the IRS could decide that you weren't eligible for the Streamlined procedure. That's been eliminated. So what are the eligibility requirements? We have to look at 3 sets of them. One are general eligibility requirements applying to taxpayers residing both inside and outside the U.S., and then there are a separate set of requirements, one for taxpayers inside and the other ones for taxpayers residing outside the U.S. So the general eligibility requirements that we have, let's go back. It's only for individual taxpayers and their estates. So corporations, partnerships, we just had an LLC that we were hoping to put into the new streamlined procedure but couldn't. So that's one limitation. But frankly, I know that most of the OVDP taxpayers that we see are individuals or estates, so it's not going to be a significant limitation, I wouldn't think. There must be a failure to file FBARs and the failure to report all income and a failure to submit all required information returns. All of that must be non-willful. And this is very important, so we'll come back and talk about non-willful later, because everybody thinks that they're non-willful, and in the eyes of the IRS, not everybody is. It's in line with the OVDP. It's not available to taxpayers who are currently under audit or criminal investigation by the IRS. It's also not available to those taxpayers who submitted full voluntary disclosure letters after June 30th, 2014. So what that means is that you have to make an election up front. In other words, you can't, if you've applied for OVDP, you can't change your mind and then go back and enter the streamlined program. Now, there's some transitional rules. We'll talk about that, but that's generally how it works. Also, taxpayers who finalized the Form 906 closing agreement under prior OVDPs are not eligible. So there's going to be a whole bunch of rather unhappy people who paid anywhere from 20 to 27.5%, who believed that their actions were non-willful, decided not to opt out because they were scared about getting hit with 50% penalties, and are now learning that people who are coming in now may be able to get through this with only a 5% penalty. So what are the benefits of going into the streamlined program? Well, only 3 years of tax returns need to be filed. In the OVDP, it's 8. There's a 5% offshore penalty for domestic taxpayers, and for foreign taxpayers, those individuals living outside the country, the penalty is 0. For both groups, there's no accuracy penalty, no FBAR penalty, and there's a lot less paperwork than under the OVDP. So for people who qualify, I mean, this is a really good deal. But like with anything else that the IRS does, there are some downsides. So what are they? First of all and foremost, there's no protection from the risk of criminal prosecution. So if your client were to go into go into the streamlined program, and the IRS were to disagree that the non-filing had been non-willful, or to put it a different way, thought that the non-filing had been willful, the IRS could initiate a criminal prosecution. Unlike under the OVDP, where even if the client's actions were willful, the IRS has stated that it will not pursue criminal prosecution. Another downside I alluded to before, which is that if the IRS determines that the streamlined compliance procedure is not appropriate for your client, the taxpayer may not now go back and go into the OVDP and get 27.5%. They're now exposed to the full range of penalties. As part of the process in the Streamlined program, the taxpayer has to sign a certification under penalties of perjury indicating that their actions were non-willful. If the IRS disagrees, then in addition to the possibility of criminal prosecution for the failure to file the FBARs and the omission of income on the tax returns, there could be a prosecution for submitting a false statement to the IRS. And of course, this is not a do-it-yourself project for taxpayers. There's still going to be a substantial amount of legal and accounting work that needs to be done. And I would focus on that very last bullet point, which is an analysis to determine whether or not the client's actions were willful or not. Because submitting a streamlined request in a case where the IRS deems the compliance, deems that the client's actions were willful could be a disaster, both from a criminal standpoint as well as a civil standpoint, because now the IRS is focused on the client. They can't get 27.5% in the OVDP, and they've got a lot of exposure. So in my opinion, this is a very important analysis that needs to be done up front, and clients should not lightly be advised to simply go into the Streamlined program and sort of hope for the best. So, as I mentioned, in addition to meeting the general eligibility provisions, there's separate eligibility requirements for both the foreign and domestic taxpayers. We've got the eligibility requirements. The first three bullet points are going to be the same for both domestic and foreign taxpayers. If you look at the fourth bullet point, though, there are applicable non-residency requirements that must be met in order to enter the Streamlined Foreign Offshore program. And remember, it's only under the foreign offshore procedures that the penalty goes to 0. So the non-residency requirement is, as you can see, that in any one of the most recent 3 years, the individual was outside of the U.S. for at least 330 full days. So this is going to trip up some of these so-called Canadian snowbirds, people who, U.S. citizens or green card holders who live more or less full-time in Canada, but who come to the United States to get out of the winters. And some of them, you know, they'll have a place down in Florida, and they'll come here. And when you start counting up the days, they're here for more than 35 days or so, and lo and behold, they're not going to qualify under this procedure. Okay. So we'll talk about the scope and effect. Again, qualifying taxpayers will not have any FBAR penalties, no late filing penalties, no accuracy penalties, no information return penalties, and no miscellaneous offshore penalties. So again, great deal if you qualify. Taxpayers can get retroactive relief where there are, and this usually applies to Canadians who have RRSPs or other retirement accounts, you're required to make an election on your U.S. tax return if you don't want those Canadian retirement plans to be currently taxable in the U.S. A lot of people didn't know about that election, and under the Streamlined Procedures, you'll be able to make a late election and therefore exclude any income on the Canadian retirement plans from taxability, from current taxability in the U.S. So what do clients need to do to get into the Streamlined Foreign Offshore program? Basically, they file amended or original tax returns for the past 3 years. They have to pay the full amount of the tax and interest due along with the return. It requires the electronic filing of a full 6 years of FBARs, and again, the completion of the certification. This certification is on a form that's provided by the IRS. It's a fairly lengthy form. It has to include a statement that the failure to report all income, the failure to pay all tax, and the failure to submit all required information returns, including the FBARs, was due to non-willful conduct. And the certification has to set forth specific reasons for the failure to report. So there's, 3 parts to this. There are essentially 3 certifications: that the client was not willful in failing to report the income, that the client was not willful in failing to pay all the tax, and the client was not willful in failing to submit all the information returns, including the FBARs. Well, for a lot of clients, it might be fairly easy to say, well, never heard of an FBAR, didn't look at the tax return too closely. Gee, I'm sorry, but I certainly didn't intentionally fail to file the FBAR. But the client is also certifying that the failure to report all of the income was also non-willful. And I think that's a bigger stretch when there's, significant amounts of unreported income from foreign sources. And I think there's going to need to be a good explanation of the facts as to why the client didn't report the income that was being earned overseas. The eligibility requirements for the domestic offshore procedures are very similar to those for taxpayers living overseas. The big one to focus on here is bullet point number 4. So for taxpayers who live overseas, it doesn't matter whether or not they previously filed a tax return. They're still eligible for the program. However, if a taxpayer living in the United States failed to file a timely tax return for each of the most recent 3 years, then that person will be ineligible to participate in the Streamlined Domestic program. So that's an important consideration. Under the Streamlined Domestic Procedures, there's a 5% one-time offshore penalty. Again, just like with the foreign procedures, there's no late filing penalties, no FBAR penalties, no accuracy penalties, no information return penalties. Also, you can get retroactive relief on these Canadian retirement plans. So that's, again, all the same as the foreign program, but under the domestic program, it's a 5% penalty as opposed to 0. Again, very similar procedures. Amended returns get filed for the past 3 years. The full amount of the tax and interest must be paid, along with the full amount of the 5% offshore penalty. That must be submitted along with the returns when they're filed. Now, under the OVDP, if an individual wasn't in a position to make a current payment of the offshore penalty, it was possible to set up some sort of payment arrangement. It wasn't very common. The IRS has been pretty strict about allowing for that, but that is a possibility under OVDP. There's no indication that that would be available under the Streamlined program. What about calculating the 5% penalty? Well, it's 5% of the highest aggregate balance of the value, aggregate balance or value of the taxpayer's foreign financial assets that are subject to the penalty. You look at the value during both the covered tax return period, which is 3 years, and the FBAR period, which is 6 years. So essentially, you're looking at a 6-year period. You look at the highest aggregate value. Under the OVDP, you look at the highest value at any time during the year, each year. Under the Streamlined program, you calculate the highest value as of the end of the year. And the foreign financial asset has to be included if, during the covered FBAR period, if it should have been but was not reported on an FBAR. And the 5% penalty is also applicable if, in a given year, during the 3-year period, if the asset should have been but was not reported on a Form 8938. And also it'll be applicable if, during the covered tax return period, the 3-year period, if the asset wasn't properly reported for that year. I'm sorry, even if it was properly reported, but gross income from that asset went unreported. That last bullet point is pretty important. Under the literal language of the program, if the taxpayer had signatory authority over an account, it would appear that it would be included in the penalty base because there's no exception. Under the OVDP, if you have signatory authority only, and therefore you have no income, then it's not included in the penalty base, but that exception doesn't appear in the literal language of the Streamlined compliance procedure. So again, we're going to have to see whether or not the IRS issues some clarification on this issue. So non-willful conduct, very important concept. The IRS states in the procedures that non-willful conduct is conduct that is, quote, due to negligence, inadvertence, or mistake, or conduct that is the result of a good faith misunderstanding of the requirements of the law. And they also point out that if this certification isn't submitted, then the Streamlined request will be rejected summarily, and the returns are going to be processed in the normal course without the benefit of the favorable terms of the Streamlined compliance procedure. In analyzing what constitutes non-willful conduct, at a couple of the seminars that I've listened to where IRS people have spoken, they've said that we should be referring to, quote, existing case law as the standard for determining willful conduct. So what they're talking about are cases like Zwerner, which I mentioned a moment ago. They're talking about the Williams case, the McBride case, and you need to take a look at these cases because they're problematic. They're cases where the IRS has pursued a civil willfulness penalty, and while those cases included bad facts, the courts also made extremely broad statements about what constituted willful conduct. So, for example, one of the courts said that a taxpayer is presumed to know the contents of his return, and the fact that there was a Schedule B and the box was checked no, that there were no foreign accounts, and that was untrue, even though the taxpayer maintained that he hadn't looked closely at his return and therefore wasn't aware of that statement. The court just sort of rejected that idea and said, no, we're charging you with knowledge of that information. Frankly, that case is probably wrong, but it's somewhat disturbing that the IRS would suggest that it's going to rely on a case like that to determine to determine how or whether or not there was non-willful conduct. So, last thing I want to touch on for the moment before I hit a few questions is avoiding malpractice. And really, you need to take a look at Circular 230. It provides that a practitioner may rely without verification on information provided by a client. On the other hand, the practitioner cannot ignore the implications of the information provided. And it goes on to say that good faith reliance contemplates that a practitioner will make reasonable inquiries when a client provides information that implies possible participation in overseas transactions in an account. And what that suggests, and even without that, I think that the practitioner, when working with a client, can't simply rely on a statement by the client that, oh, what I did wasn't willful. I think you need to explore in some detail with the client why it is that they didn't file the FBARs and why it is that the offshore income went unreported, and look at that information in light of the case law out there, and be prepared to fully defend the argument that what was done is non-willful, because you're exposing yourself to, as a practitioner, to two problems. If you submit a case under the Streamlined Procedures with a certification that what the taxpayer did was non-willful, you expose yourself to potentially being a co-conspirator with the client and submitting a false statement. And in addition, if the client gets rejected from the program, then the client may come back and say, well, wait a second, why did you put me into this? Now I've got exposure to a 50% penalty. Why didn't we just pay the 27.5%? So those are two things you need to think about before you just sort of willy-nilly submit under the Streamlined Procedure. So we got a few questions here, which I have time to answer. The first one is, if a taxpayer completes the audit process, are they eligible for OVDP? And I assume what that means is let's assume somebody is undergoing an audit. We've said that they are therefore not eligible to go into the OVDP. Now the audit's over. Are they now eligible? And the short answer is, as far as we can tell, yes. We've had some conversations with the IRS, and in the past, they've said that, yeah, if just because you've been audited, once, that doesn't mean that, yeah, you're forever disqualified from entering the OVDP. Question number 2, regarding public disclosure. If an FFI discloses the U.S. person's account in the institution under FATCA, is there a public disclosure such that a 27.5% penalty is not available? Well, first of all, a disclosure under FATCA is not a public disclosure. That's a disclosure by the institution to the IRS. That wouldn't be a public disclosure. An interesting question, though, is that one of the other disqualifying requirements under OVDP is if the IRS has specific information regarding the client's accounts. And I have not, it's sort of an interesting question. I mean, arguably, if the IRS has information that it receives under FATCA, then they already have information about the client's account, and therefore they couldn't go into OVDP. Somehow, though, I doubt that that is going to be the interpretation by the IRS, because ultimately what that would mean is that there would be no OVDP program. The exception would swallow the rule. So I doubt that a disclosure under FATCA would disqualify somebody from OVDP. The final question is, if an account is held at a bank on the DOJ list, is the Streamlined program available? And I've been sort of wondering about that myself. If you look at the Streamlined procedures, there's nothing that indicates that the public disclosure will disqualify somebody from going in under the Streamlined program. And in fact, even under the OVDP, they're not barred from the OVDP. The penalty is just higher. So looking at this, at least from a literal point of view at the moment, it seems to me that even if somebody is on the DOJ list, they're not barred from the Streamlined program. My thought would be, though, that if you have somebody who's at one of these banks and they're thinking about the Streamlined program, it would be nice if you could get them in by August 3rd, but I recognize that given the fact that you would have to have several years' worth of tax returns prepared and a lot of information, that's probably not a practical alternative. All right, that covers everything. I'd like to thank each of you for listening to the program and sticking it out. And, everybody have a good lunch and a great afternoon. Thank you.